Pessoal, bom dia, boa tarde, boa noite. Aqui são 10h30 da noite. Estou gravando aqui na correria, só consegui agora. A entrevista de hoje foi com um professor aqui de Harvard, o professor Michael Klarman. A gente conversou sobre um artigo que ele escreveu em 2019, mas que a gente fez uma atualização dele para os dias de hoje, sobre a degradação da democracia nos Estados Unidos partindo da Suprema Corte americana. E como, na visão dele, a Suprema Corte tem derrubado uma série de precedentes estabelecidos que eram a lei da terra aqui, e como isso tem avançado uma agenda antidemocrática, e como até existem fundamentos dentro da Constituição que permite que essa agenda se avance, fundamentos que são essencialmente antidemocráticos dentro da Constituição norte-americana. Conversamos bastante, lá pelo final a gente tem uma conversa sobre court pack, né, empacotamento da corte. A gente tem umas discordâncias, mas assim, o professor tem uns argumentos bem do ponto de vista pragmático, eu concordo, do ponto de vista normativo do dever ser, eu tenho sérias discordâncias, mas assim, acho que a conversa ficou bastante bacana e eu espero que vocês gostem. Lembrando que esse podcast é apoiado por meus queridos contribuintes, tem mais de acho que quase 200 pessoas lá no nosso Apoia-se. O pessoal que está no Apoia-se recebe os episódios com antecedência, lá nos nossos grupos, tanto no Telegram quanto no WhatsApp. Tem o recebimento de livros do nossa curadoria também. Se você se interessa, se o Onze faz parte da sua vida, se o Onze faz parte da sua semana, se ajuda a melhorar seus argumentos, te deixa um pouco mais capacitado, não deixe de dar uma conferida lá no nosso Apoia-se. Qualquer ajuda é bem-vinda, a gente agradece muito. Nós também temos dois patrocinadores aqui, um deles é a minha querida Contra Corrente, tem o cupom de desconto da Contra aqui na descrição do episódio. Qualquer livro que você queira comprar no catálogo da Contra com 25% de desconto, é só você acessar lá e usar o Onze Supremos 25, tá na descrição o link aqui para quem quiser pegar. Contra também tem um clube do livro maravilhoso, lá te manda 2 livros por mês, às vezes com coisas inéditas, eu acho que um deles é sempre inédito e o outro é do catálogo da Contra, então vale muito a pena para quem está querendo dar uma renovada no acervo ou dar uma incrementada na biblioteca. E também meu querido Felipe Augusto, lá como coordenador e criador do Ouse Saber Cursos Jurídicos, para aqueles que se preparam para as grandes carreiras dos concursos públicos, como magistratura, Ministério Público, Defensoria Pública e procuradorias. O Felipe aí tem nas costas ajudado mais de 5.000 pessoas nas aprovações e eu acho que o Ouse Saber deve ter muita coisa de qualidade que vai te ajudar a encurtar essa caminho até a aprovação. Meu nome é Davi Sobreira, esse é o Onze Supremos e eu espero que vocês gostem do episódio de hoje. Hello, everyone. I'm once again with a Harvard professor here. Last time I think Harvard went in this podcast, it was, I don't know, maybe 3 years ago with Professor Tushnet before he retires in one of his latest books. And today I have the honor and the opportunity to talk with Professor Michael Klarman, who is my professor in Harvard Law. I'm attending his course on Constitutional History 1 from the founding to the Civil War. And before we start our conversation, let me pass the mic for Professor so he can introduce himself to you. Professor?
Thanks so much. So, Michael Klarman, I teach constitutional law. I teach constitutional history. I've written some books on race in the Constitution. I wrote a book about the American founding, the founding of the Constitution, the Philadelphia Convention, and the ratification. I wrote a book about same-sex marriage litigation and political backlash and how the court ended up protecting gay marriage under the Constitution 10 years ago. I've been teaching since 1987. I taught for about 20 years at the University of Virginia and the last 15 or so years at Harvard, 15 years, 17 years, I guess. And I'm working on a book now, which is not actually about law, though I think it has lots of applicability to law and many other things in life. And that's a book about the history of race and sports in the United States, roughly from the Civil War to the present. So that's been a very interesting and fun topic for me to learn about.
Professor, we're going to talk about a main article you wrote in 2019, a foreword, on what you are seeing is the degradation, what you call the degradation of the democracy in the US and also of the Supreme Court. Let's start with a bit of context. What were you seeing in the main picture that led you to write this piece? Because we didn't see yet, we are seeing, of course, Trump enacting, but we didn't see yet things like Eleni, Loper-Bright, Bruen, Bemerton, and even Dobbs, that there was not in the horizon at the moment. So I know that was a bunch of cases that were happening in the past decade, especially in electoral cases and administrative law. But what points, especially from the Supreme Court, prompted you to see this degradation in this particular institution?
Sure. So a little bit of background. The students asked me in the fall of 2019 if I wanted to write the Harvard Law Review foreword for that year's term. So it's supposed to be on the court's decisions in 2019 through the end of the term in 2020. I My initial reaction was I wasn't sure I had that much to say, but I'd been thinking for the last few years about the decline of democracies around the world and the degradation of democracy in the United States. A lot of that has to do with Trump, but some of it has to do with the Supreme Court. So I decided that was a topic that I'd been thinking about and reading a lot about, so I would write the foreword about that. There is this thing kind of informally known as the authoritarian playbook. It's what Viktor Orban does in Hungary. It's what Duterte does in the Philippines. It's happened in Brazil. It's happened in Israel. It's happened in Poland. I'd been talking about that since just before the 2016 election. Trump doesn't read, so he would not have actually read the authoritarian playbook, but he very much intuits it almost more than any current figure on the world scene. So in the election of 2016, he was saying and proposing the sorts of things that you would expect from an autocrat. He, for example, was refusing to say he would accept the election results if he lost. He was encouraging violence. He was attacking the media. And the court had played its role. So even before, as you said, the court was expanding the right to keep and bear arms or overturning the right to abortion, the court had been undermining democracy. So it's way back in 2013 that the court struck down a key provision of the Voting Rights Act. For the last 40 or 50 years, the court has been protecting the role of money in politics, including corporate money. The court in, I guess, 2019 had a chance to eliminate partisan gerrymandering, which is a real threat to democracy, and had refused to do it. So even apart from all the big culture war issues in the United States on abortion and race-based affirmative action and gun control, on the issues that are more directly about democracy, the court was, to my mind, clearly on the wrong side of those issues, and at a time that you had a pretty openly authoritarian president in office, that seemed like a connection that was worth making.
Professor, you wrote looking to what, especially was what Trump was doing to the system, and today he's back, and we are today, I know, close to the first month of his administration, and he has done something like a blitz. He has made several executive orders and made numerous modifications, some of those quite connected with cultural war that has no impact whatsoever. And I think the best thing I saw in the internet was
when he changed the name of the Gulf of Mexico to Gulf of America, and someone tweeted, "So how this affects the price of eggs?"
Right.
That was the best thing I saw recently. But if I may, you were talking about at that moment in 2019, looking back to the 2, 3 years of Trump administration and how he was undermining the checks and balances and even sociological norms that are underlying to the American democracy. Today, in his first term, in this almost 30 days, what have you been seeing that is worrying you, troubling you in his first government days?
Well, he's done, somewhere between a half dozen and a dozen clearly illegal and or unconstitutional executive orders. So the president doesn't have the power to revoke birthright citizenship. The president doesn't have the power to refuse to spend money that's been appropriated by Congress. The president doesn't have the power to fire members of independent agencies. The president doesn't have the authority to fire inspectors general in the way that he's done. The president doesn't have the power to shut down agencies, entire agencies. So he's done a lot of things that are deeply troubling. He does have the power to pardon people, but you would hope he wouldn't pardon violent insurrectionists, therefore essentially creating open season going forward, because anyone now who commits political violence on behalf of the president has an implicit kind of promise that they'll be pardoned for whatever they do as long as they're on Trump's side. Maybe most troubling is what he's doing just in the last couple of days with regard to the Southern District of New York. His administration has fired the U.S. attorney there because they've refused to drop the prosecution of Mayor Eric Adams. And it's pretty clear what happened was there was pretty much an explicit deal made between Trump and the mayor. So the mayor is being prosecuted and would probably go to jail. He's innocent and he's presumed innocent until proven guilty, but the case seems pretty overwhelming. He took bribes and he solicited illegal contributions from foreign governments. The president made a deal, basically. I will drop the prosecution if you stop criticizing my immigration policy and if you facilitate the enforcement of immigration laws in New York City rather than obstructing them. That led a half dozen people in the Justice Department to quit. That's about as political a use of the Justice Department as you can imagine. He's also fired prosecutors. He's fired FBI agents. So there's a lot to be concerned about. The two things that I'm most concerned about, I think, are that the president is facing zero constraint from his own political party. So in some ways, the most surprising and troubling thing he's done is all the utterly incompetent and really quite terrifying appointments to his cabinet. So, just to take one at random, but there are 4 or 5 who fit in this category. The Secretary of Defense, Pete Hegseth, has no qualifications to be Secretary of Defense. He was a soldier and a Fox News host. So even if you leave aside all the credible allegations that he has a drinking problem, that he has a sexual assault problem, that he has a Christian nationalist problem, that he has a problem with the truth, leave all that aside, he has no qualification to be Secretary of Defense. Yet 50 out of 53 Republican senators who purport to have taken an oath to the Constitution and profess a love of their country were willing to confirm him. Same thing, and in some ways maybe even more troubling, Robert Kennedy to be the head of Health and Human Services, perhaps on the brink of a bird flu pandemic. We have somebody who doesn't believe in vaccines, somebody who believes conspiracy theories about medicine, and somebody who has absolutely zero experience in public health or medicine or running a hospital. And again, you have 52 out of 53 senators, Republican senators, who purport to love their country, who have now put somebody just really unbelievably unqualified in charge when we may very well have a pandemic in the near future. So I've been surprised by that. The other thing I've been surprised by is the utter capitulation by the media and the corporate billionaires. So, three of the richest people in the world sit behind Trump at his inauguration. One of them, 4 years ago, contributed a significant amount of money, tens of millions of dollars, to make sure that the electoral machinery worked during the pandemic. Another one bought the Washington Post years ago and instituted the slogan, "Democracy dies in darkness." And now that same person, Jeff Bezos, says he killed an editorial endorsement of Kamala Harris, and he fired, or his editor fired, a cartoonist who wanted to say that the billionaires were kissing up to President Trump. Mark Zuckerberg made a pilgrimage to Mar-a-Lago. He settled. He's given the Trump. He's Zuckerberg, I think, settled lawsuits, gave Trump $25 million to settle a lawsuit after he was kicked off his Facebook account. These are the richest people in the world, and they are submitting to Trump even before he's done anything to them. And the same thing with the media, CBS and ABC, settling defamation suits, ridiculous defamation suits that have no legal merit, just giving tens of millions of dollars to Trump, because so much of their business depends on government contracts and government licensing, that they're scared to death that he'll use the levers of power to disadvantage them. And there's no question he will do that. He said he would do that. He's quite open during the campaign about his authoritarianism, yet Americans elected him president anyhow. So those are the things that are most troubling to me. I think going forward, I worry a great deal about political violence. I think Trump has, in the past, directly encouraged violence. He incentivized violence by liberating violent criminals who tried to overthrow the government. We now have pervasive death threats against election officials, public health officials, judges. I worry about that a great deal. I don't think we're that far from that.
Professor, in a federal level, the checks and balances seem to be very weak for the next following years. But America still counts with a big structure in the subnational level. So I remember when a professor said that most of the cases, for example, from Texas, come from 2 or 3 different judges or courts. And of course, this happens to other more democratic leaning states as well. And we see, for example, there's one judge that suspended one of the executive orders that tried to take the birthright citizenship, for example. I would like to, before we go in this way, to try to analyze what Trump is doing right now and what the Supreme Court could eventually do in judge these cases. I would like to try to update your article a bit with most recent cases, because you have cited a bit, but we have some cases that came after. And for example, in the administrative era, in the administrative field, we got, for example, SILA law that indicates how the court has been trimming the administrative state and restricting the possibility of agencies to eventually develop the work they were embedded to. In electoral cases, I think the last case I remember, maybe you cited it was Brnovich, but we got Ted Cruz v. the FEC, I remember correctly, and they practically authorize some kind of corruption when you can get money from donations after the campaign is gone. And if you won, that is counted kind of ludicrous. But I would leave the mic open to you to cite some cases that you have been seeing after this forward in 2019, that it seems to you that the Supreme Court is keep going on the path to degrade the system of checks and balances established by the Constitution.
Sure. There've been a lot of cases. I think many people, when I wrote the foreword, treated me as an alarmist. And in fact, I think most people who pay attention to this stuff now would say that probably I understated the severity of the threat, especially as evidenced by what's been going on in the last month. So the most notable case is the presidential immunity case. Last term, the court over the summer said by a 6-3 partisan vote that the president has immunity from most things he does during his time in office. From my perspective, that's completely made up. It's not what the framers had in mind. The Constitution.
Imagine Lincoln seeing a decision like this,
I don't think
or
anybody can
Ford.
imagine this. Yeah, right. The reason why Gerald Ford pardoned Richard Nixon is because everybody assumed Richard Nixon would be criminally prosecuted for the things that he did during his presidency, using the Internal Revenue Service to go after his political enemies, trying to get the Central Intelligence Agency to persuade the FBI to stop investigating the Watergate break-in. I think for 200 years of American history, almost everybody assumed, of course, the president was criminally liable after he left office. The complicated question was whether you could prosecute him while he was in office. But the Constitution pretty clearly contemplates criminal prosecution because it says, if he's impeached and removed from office, of course you can criminally prosecute him as well once he's out of office. So that was a pretty extraordinary opinion, and I think that is saying the president's above the law. Brnovich, as you said, is upholding voter suppression, so the court interpreted a key provision in the Voting Rights Act to allow the state of Arizona to make it harder for people to vote, Native Americans living on reservations where they don't have regular mail service, made it harder for them to vote. The Supreme Court earlier had struck down another critical provision of the Voting Rights Act. Last year, early in the year, the court said that the president could not be removed from the ballot even if he had incited an insurrection. That's a case involving an interpretation of Section 3 of the 14th Amendment, something that really hasn't been discussed much in the last 150 years. But if you look at the text of the provision and you look at the original understanding, it's actually pretty much of a stretch of an argument. I think the court pretty much should have confronted the question, well, if you think the president incited, encouraged an insurrection, then maybe he's not eligible to run for president. But the court left him on the ballot. There's the corruption case you mentioned. Today's Supreme Court's understanding of political corruption is mostly that it's fine. The case you mentioned is quite extraordinary. If you took the bribe and then got rewarded afterwards rather than before, then that isn't covered by the federal statute. That was a strained reading of the statute. You mentioned the administrative rulings. I mean, the fundamental goal of this court, more than anything else, is to undo the 20th century modern administrative regulatory state. So essentially, they would return to a pre-New Deal, pre-1930s era, meaning, the federal government shouldn't set up agencies that regulate the environment, that regulate labor relations, that regulate the stock market, and certainly shouldn't engage in redistribution like with Social Security, old age pensions, unemployment, medical insurance for the citizenry. They just want to go back a century and return to an era in which the federal government just didn't do very much, and you had lower taxes and less regulation and less of a safety net. And that's what the administrative decisions are. And they're quite revolutionary. I mean, they're overturning doctrines that have existed for decades, or in some cases, almost 100 years. And nobody gave them authority to do that. They didn't say they were going to do that when they were nominated for the Supreme Court. Nobody voted for that. But it's pretty much the same thing that Elon Musk is now doing within the executive department. So all of that is, by way of undermining democracy, turning the president into a king, undoing the modern administrative state. And then, of course, on top of that, on all the big the big culture war issues, they've again been quite revolutionary. So Roe versus Wade has been the law of the land for 50 years. It's been reaffirmed by the Supreme Court more than you can count. they overturned that. Race-based affirmative action has been, with qualifications, okay, constitutionally permissible for 50 years. They've essentially overturned that. They're expanding on their Second Amendment decisions, basically inventing novel interpretations of the Second Amendment in a country that has the worst gun violence in the world. It's really quite extraordinary. So, this is a kind of right-wing court run amok, and it's a threat to democracy, and it's protecting a president who's made it pretty clear that he doesn't believe in the rule of law. That's pretty unprecedented and pretty dangerous.
Professor, let me draw a bit from your expertise in constitutional history. How would, for example, the framers see the decisions? I'm not talking about the administrative state, but they could not foresee something in like the emerging of the size of an administrative state. But let's talk about presidential responsibility. Let's go back, for example, to Trump v. Anderson and Trump v. United States. What would be a lessons that we could draw from the founders and from American history regarding the presidential responsibility, presidential accountability to what Trump has done, and to, for example, what happened between in January 8th, no, January 6th, I'm confused, I'm mistaken with Brazilians.
Right.
What happened in Brazil, it was January 8th. But both in Trump v. United States, that we see the part of criminal responsibility, and Trump v. Anderson, when we see the attempt to take him off the ballot using the 14th Amendment, what prompted Professor, I think, Will Bode to write an article with another professor that got over 100,000 downloads in SSRN, as far as I remember.
Yeah. So let's start with the framers. The United States fought a revolution against Great Britain, and if you go back and read the Declaration of Independence, which is essentially a bill of particulars, an indictment of Great Britain, the first grievances that the colonists had to do with the king abusing his power. So Americans saw themselves as revolting against the abuse of monarchical executive power. That's why when the states were writing constitutions during the Revolutionary War, they created very weak executives. So the executive tended to be selected by the legislature with often just annual terms in office, and they were often constrained by executive councils, meaning they couldn't act without the acquiescence of other officials. Most state governors did not have the power to veto legislation. They didn't have the power to make appointments. So very weak executives. The framers of the Constitution, who were writing 10 years later in 1787, to some extent, the pendulum had swung back. They'd been very unhappy with some of the actions of state legislatures during the preceding few years, especially state legislatures capitulating to populist demands for tax relief and debt relief. And they actually wanted to create a stronger executive. So the president has a 4-year term, and the president is eligible for re-election, and the president is not constrained by a council, and the president has a qualified veto, and the president has a broad pardon power, and the president plays the dominant role in making appointments to the federal offices, and the president negotiates treaties. But they didn't want a king, so the president can be impeached and removed from office, and they were pretty clear the president could be criminally punished after leaving office, and they didn't give the president an unqualified veto. They didn't give the president the power to declare war. That's a power that Congress has, and Congress has the power of the purse. Over the last 200, and it's quite clear from early in the Republic, if you look at the way Congress interacted with early presidents, that the president conceded that Congress was the rulemaker, and that the president was more, I don't want to say an errand boy, but the president enforced the law, and the president was not imperial. So when Congress was regulating, when the United States almost went to war with France in the late 1790s, and the Congress, gave the president some authority with regard to creating a navy, Congress specified in great detail exactly what the president could do with these new boats to avoid getting us into an unnecessary war, things that nobody would imagine Congress regulating at that level of detail. So what happened over the next 200 years is, for a bunch of reasons, which have to do with the nature of the world and the nature of communication and the nature of the United States' role in international affairs, the president accumulated more and more power. So the United States went from being an isolationist nation to being the one of the two great superpowers, and then for a period the only superpower. The United States developed nuclear weapons, which the president, as commander-in-chief, has the discretion to use. Modern communication enabled the president to speak directly to the people, first through radio, then television, now Twitter. The United States developed a massive administrative state, and in some sense, the president runs that by appointing administrative agency heads who make policy decisions that implement the president's policy. So and the party system developed in a way that the president's the head of the party and other members of the party may have incentives to fall in line. So the president became more and more powerful. And I wouldn't criticize that. I mean, I actually think a flexible understanding of the Constitution that enables it to adjust to changed circumstances makes a lot of sense. But the president became a lot more powerful. And some people want it to be even more powerful. So beginning with the Reagan administration in the 1980s, there were this group of conservatives who wanted the president to be able to fire anyone in the executive branch, and they didn't like the idea of an independent counsel. And there were arguments made about presidents having the right not to spend funds that Congress had appropriated, call those people the unitary executive people. This was a view that developed in the Reagan Justice Department in the 1980s. And the Trump people are taking that to an extreme that threatens the rule of law. So their view is the president can fire everybody in the executive branch. Their view is the president doesn't have to spend funds appropriated by Congress. There aren't lots of things that they seem to believe that the president can't do and that only Congress can do. And
J.D. Vance has said that with all the letters.
J.D. Vance has said that the president may need to and probably should just ignore court decisions at some point. So, as you mentioned in the question, the Supreme Court said no criminal responsibility. The Supreme Court helped elect Trump president in 2024. They delayed the criminal. First of all, they said early in the year, they rushed to a decision saying Trump cannot be disqualified from the ballot. And then they delayed a decision and made sure that cases didn't go to trial, alleging that Trump had committed crimes, which he pretty clearly did. The cases were very strong. So if it had not been for that, there's a decent chance Trump would not have been reelected. And now they've said to the president, go ahead and do anything you want. I mean, literally, he can tell the Justice Department to go prosecute his enemies. He can tell the Attorney General to prosecute Liz Cheney. He can call the Secretary of Defense or the Secret Service and say, go and assassinate my political rivals. Those are almost surely protected by the Supreme Court's decision because those are within the official responsibilities of the president. He gets to talk to his Attorney General, he gets to talk to his Secretary of Defense, and the Supreme Court said basically anything he does in those contexts are immune. Now, we don't know what they'll do about the other stuff. Will they say he can refuse to spend billions and billions of dollars appropriated by Congress? Will they say he gets to fire independent agency heads? Will they say he gets to fire people who are protected by civil service? Will they say he gets to revoke birthright citizenship? We don't know what they'll do. The evidence from looking around the world is that courts don't always stand up to authoritarians, especially when a lot of the judges were appointed by the authoritarians and may sympathize with a lot of their policy agenda, and where the authoritarians may be powerful enough that the judges don't really dare to stand up to them. I mean, I think we've seen a lot of that, for example, with the Indian Supreme Court, but you certainly see that in countries, that are more openly authoritarian. Judges in in Russia are not going to stand up to Putin unless they want to find themselves falling out of hotel windows. So I don't know that we've gotten that far. I don't think we know what the Supreme Court will do. But Trump versus United States is a pretty extraordinary decision. I would not have thought 10 years ago that anybody on the Supreme Court would think it was a good argument that the president was criminally immune, and yet all 6 Republican appointed justices agreed with that.
Before my next question, Professor, there's one point for those who are listening to us, for they not to take this as an oversizing of the decision, because you said, oh, he can tell his officers to assassinate his rivals, because that was a question I think Kagan did to one of his attorneys during the hearings of the case. I think it was Kagan or Sotomayor that asked the lawyer, oh, so it was something like, oh, so you are saying in your line of reasoning that if the president would ask someone to assassinate a rival that is within his prerogatives, and the lawyer kind of, oh, I don't know what to do. This is a kind of particular situation. I couldn't answer that hypothesis. I think I remember something of a sort, if I'm not mistaken, of course. But my next question is turning back.
Can I just elaborate on that? You're exactly right. You're exactly right. And the lawyer understood that that was a question that was intended to be a reductio ad absurdum, and he didn't want to embrace the premise that the president could do that. But John Roberts' opinion is actually pretty clear. So one of the things that Trump was alleged to have done in the criminal indictment is he went to his attorney general and he said, I want you to write a letter to the state of Georgia saying that there was election fraud, and it doesn't matter whether it's true or not. I just want you to say it. And the Supreme Court made it clear that that is protected. His conversation with his cabinet member, even if he was asking for clearly unlawful behavior, which the president himself admitted was not factually grounded, that's part of his official duties, is to have discussions with his cabinet members. So if the president says to his Secretary of Defense, I want you to have military snipers go out and shoot Adam Schiff because the senator from California has been criticizing me, I think the Supreme Court decision is quite clear that you do not have the authority to interrogate the president's conversations with his cabinet members.
Professor, now I want to turn our conversation to the basis of court legitimacy, which is the core of what I wanted to discuss with you. You talk in your article about how the levels of polarization and the politicization of justices have been affecting the court's legitimacy, and how bad this is for the court's integrity and for the respect of their decisions.
Well, my own view. Go ahead.
Professor Fallon, who is a friend of yours and a Harvard professor as well, wrote a book on the court and its legitimacy, and he develops the idea of three degrees, 3 dimensions of legitimacy. We got moral legitimacy, we got legal legitimacy, and we got sociological legitimacy. And one thing we always learn when you are studying these features is that people, when we deal with courts, we always say courts shouldn't take in consideration what people would think about them when they're making their decisions. But courts, paradoxically, need popular support so their decisions can be upheld. And this is where sociological legitimacy come in. And what we have been seeing in this, I think what is Professor Leah Littman from Michigan calls the YOLO court. You only live once. Roberts' court is tearing down. It's usually to be piece by piece, but is kind of increasing the rate of in which Roberts is doing it. But we are seeing the degradation of the precedents, and the court is in its lowest approval rate in, I don't know, decades, maybe 3-4 decades or more. What have you been seeing about these levels of politicization of justices, and what are the consequences we will think will come to the court in the next few years about this? Because we can't expect a court to make a shift to a liberal majority for at least in 15 to 20 years at minimum.
Yeah, I think if Democrats don't pack the court, Democrats will not have a liberal majority for the rest of my lifetime. So the justices have always taken into account what people will think about their decision. So I think courts, and maybe to be more precise, judges have always taken into account public opinion. When Chief Justice Marshall in Marbury versus Madison kind of declared the power of judicial review, he was not ordering President Jefferson to do anything because he knew he couldn't enforce the decision. The court famously in 1937 seemed to backtrack in its decision, striking down the minimum wage law, striking down New Deal provisions because Roosevelt was threatening to pack the court, and Roosevelt had just won a massive mandate in his reelection campaign. After the court decided Brown versus Board of Education the next year, it told the white South that it didn't need to desegregate very quickly. It could do it incrementally. During Reconstruction, the court pretty clearly was making accommodations as public opinion became less supportive of the rights of African Americans in the South. So I think judges have always taken into account kind of what they can get away with. They don't want to alienate public support. For probably almost 50 years after the end of the Warren Court, so the Warren Court, the most liberal court in American history, ended in 1969. For almost the next 50 years, the justices, were kind of divided. The swing vote, the median justice was a little bit right of center, but they weren't very right of center. So even though the court might, for example, strike down campaign finance reform or uphold the death penalty, the court was still allowing race-based affirmative action, and the court was still upholding Roe versus Wade and allowing women abortion rights. What's happened since Justice Kennedy left, Justice Kennedy was the swing vote, and he quit in 2018 so that President Trump could replace him with another Republican appointee before the 2018 midterm elections. Justice Kennedy was the swing vote, and he's gone. So, Justice Scalia had died in 2016, and the Republicans in the Senate had prevented President Obama from replacing him. So Justice Scalia was replaced with another conservative, but then Kennedy was the swing vote left, and he was replaced with another conservative, and then Justice Ginsburg died, and she was replaced with another conservative. So the court went from 5-4, liberals winning sometimes, conservatives winning sometimes, to 6-3, liberals losing pretty much all the time, except when the most extreme arguments were made. So while Democrats and Republicans might have both been willing to pretty much cut the court a break and be supportive, now Democrats have no particular reason to think of the court as anything other than a bunch of partisan hacks who write Republican policy into the Constitution. This is the most conservative court clearly in 100 years. That's not a exaggeration. I think political scientists would all agree with that. But Democrats have won presidential elections in 7 of the last 9 elections. So why in the world do we have the most conservative court in 100 years when the country, if anything, seems to have been trending left in presidential elections? So that's why the court's losing support. Some of this has to do with less democratic parts of the American political system. So because of the Electoral College, which Republicans today have a significant advantage in, because of the Electoral College, Republicans can win the presidency while losing the popular vote. And because of the extreme malapportionment in the U.S. Senate that favors rural states, and rural states tend to be Republican leaning. Even if both parties have the same number of senators, each have 50 senators, the Democrats, the 50 Democratic senators represent 40 million more people than the 50 Republicans. Now, together, the president and senators choose the Supreme Court. So the Supreme Court is going to be significantly rightward tilting, even if Democrats, or Democratic voters have elected half the Senate and Democrats win the popular vote for the presidency. So that's a real problem. And, I think there's a pretty strong argument. I think you wanted to ask me about this at some point, that Democrats ought to pack the court. Let me stick now, though, to the question of legitimacy. I'm not an anarchist. I don't think you should defy court decisions. I hope Trump won't, but he will shortly at some point. I don't think Democrats should defy decisions, but that's difficult. That's very different from saying the court has some sort of moral legitimacy. The court ought to be able to educate us to agree with the court's decisions. What the justices are doing is just straight politics, and it's right-wing politics, and they are undermining democracy, and they are immunizing Trump from any accountability. And there's no reason to treat those as legitimate, law-based decisions. They're not. I mean, and I'm not saying the Warren Court was any better. I mean, the court is always political. I don't think what it's doing has much to do with law. They're obviously not doing what Chief Justice Roberts, used the metaphor calling balls and strikes. They're obviously not doing that. I don't think they've ever done that. I don't think they could do that. But, Chief Justice Roberts thinks we should bow down and refrain from criticizing the court in strong language. And I can't imagine why that's a good thing to do. The court's a fundamentally anti-democratic institution, and we should not simply acknowledge their decision and treat it as if it's some sort of biblical wisdom or something. And the framers themselves, in a very substantial way, didn't really contemplate courts governing the country in the way that the Supreme Court does today. So it's a very anti-democratic institution. It's a lead institution. Today, it's a very rightward-leaning institution. I'm not saying court judgments should be defied, but I can't think of any good reason why Democrats, when they're in charge, shouldn't pack the court, or maybe more accurately, unpack the court after Republicans packed it. And I certainly don't see any reason why we should refrain from criticizing some of their more ridiculous rulings.
Professor, I think I agree with most of what you said, especially with the diagnosis, but I'm quite skeptical with the remedy. I think the remedy can be worse than the disease in this case. In places like Brazil, India, as you have said, and Israel, we have eternity clauses. In Brazil, we have express eternity clause in the Constitution. In India and Israel, we have the basic structure doctrine that equivalates as an eternity clause. And these three constitutional court, the Supreme Courts, has the power to strike down constitutional amendments. So in these three systems, I would risk that is, at least we have seen already, at least in India and in Israel, attempts to pack the court would be considered unconstitutional and declared unconstitutional by the Supreme Courts. This wouldn't happen here in the US because the court has no authority to declare the inconstitutionality of constitutional amendments. But even so, we don't need a constitutional amendment to pack the court. But I think the packing of the court, as far my research goes, is too dangerous because it is a nuclear idea. It is a nuclear weapon, and it opens a space for people in both sides to treat something that it is nuclear as ordinary. It's like Putin or Trump going with the football and pressing the red button and throwing the nuke on the space. And this would prompt other countries to retaliate. So it is a zero-sum game. Everyone would lose because if the Democrats would pack the court, what is expected is in the next round, the Republicans would do the same or expected to do the same. And if they're expected to do the same, the Democrats would have an incentive to entrench themselves in power with all the weapons they have available at, and all the weapons the Supreme Court has made available to the executive as well. So in the long run, wouldn't you think that this way out it's too dangerous for the system as a whole in the long run?
So it's a very good question, and here are a couple different ways to think of it. The structure of your argument, if Democrats do X, Republicans will then also do X, depends on the premise. For that to be persuasive, it depends on the premise that Republicans won't do X if Democrats have not done X. And I think it's been revealed in the last 5 or 10 years that Republicans don't need to wait for Democratic misbehavior before Republicans will misbehave. So Republicans tried to overturn the 2020 election. President Trump incited a violent mob. They tried to stop the count of the electoral vote. Democrats did nothing to suggest that this should be done. Republicans did it on their own. At the state level, Republicans steal power. When Democrats elect a governor, Republican legislatures will deprive the governorship of powers that it's traditionally held. Democrats didn't do that first, but Republicans do it because Republicans are inclined toward authoritarianism. Democrats didn't try to suppress Republican voters. Democrats have not passed voter suppression laws, yet Republicans are doing that. Democrats haven't defied court rulings, yet President Trump and Vice President Vance and Elon Musk are now talking about defying court rulings. So I want to quarrel with the premise that if Democrats pack the court, Republicans will do it. Republicans will do all the autocratic things they've been doing, regardless of what Democrats do. Next point, Republicans pack the court first. So the question is simply, are Democrats going to play by the same rules? When Antonin Scalia died in February 26, 2016, Obama had 11 months left in his presidency. There was no precedent in American history for a Republican-controlled Senate to absolutely refuse to consider anybody for confirmation. So everybody I know thought for the first time in 40 years, Democrats will now control the Supreme Court. But Senate Majority Leader Mitch McConnell said, and he lied, he said, we don't confirm people in the last year of a presidential term, which was just a flat out lie.
And disregard this with Amy Coney Barrett.
Right. Well, so add that to it as well. That shows what a hypocrite he is, because 4 years later, he did the same thing in the other direction. So Republicans pack the court. And the question is, are Democrats willing to fight back with the same sort of armaments? Now, this is a hard question. I acknowledge it's hard. And you're exactly right. Autocrats pack courts. So we have to be very attentive to context and specifics, right? Autocrats, if they pack courts, does that mean that all court packing is to be condemned? And I think sometimes you have to be willing to fight fire with fire. And I don't think if Democrats pack the court, they're doing it as authoritarians. I think they are trying, and there are 2 points here. One is they're trying to undo the court packing that the Republicans already did. And second, I do think Democrats have a claim that if you win the presidency, and before 2024, they had won 7 of the last 8 popular votes for president, but because of the Electoral College, which is antiquarian and has no good justification, they only got the presidency 5 out of those 7 times that they won the popular vote. And because of the malapportionment of the Senate, which is why Republicans controlled the Senate in the year 2016 and were able to frustrate Obama's attempt to put Merrick Garland on the Supreme Court, because of those anti-democratic aspects of the presidency and the Senate, the Supreme Court was systematically biased in favor of Republicans as well. Now, you can't change the Electoral College and the Senate. You can change the Electoral College by constitutional amendment, but that's impossible to do. You can't even change the Senate by constitutional amendment. But as you said in your question, you can change the size of the court by statute. It was done all the time in the 19th century. So I think for those 2 reasons, there's a pretty good argument that Democrats were entitled to be in control of the Supreme Court. That it had been packed against them, and because of these obstacles to democracy in the Electoral College and the Senate, Democrats had been deprived of some appointments that would have given them control. Now, I would add a couple other factors to this. Everything that needs to be done in terms of reducing economic inequality, making the lives for ordinary working class people better, undermining the plutocratic agenda of Elon Musk, which in a significant way is the agenda of Donald Trump. All the populist stuff is a lie. All of those things that Democrats would like to do if they had power. So, make it easier for labor unions to organize, increase the national minimum wage, expand health care to more people, give people with student loans relief, impose a wealth tax, expand regulation of the environment, try to do something about the existential threat of climate change. All of those things will be struck down by a Republican Supreme Court. And I think Democrats need to take account of that as well. To win in politics, you need to offer people some hope that you're going to make their lives better. Democrats would like to do that by reducing economic inequality, expanding the social safety net, doing more regulation of monopolists, more regulation of employers who undermine labor unions. The Republicans, what they'd like to do is talk about helping ordinary working class Americans, but actually sow racial dissension, engage in misogynistic rhetoric, attack Muslims, attack Mexicans, denigrate people who are not white. The Supreme Court poses a threat to doing all the things that could fix the polarization and the political pathologies, which are mostly a result of the complete alienation of the white working class over the last 50 years, which is driven by acceleration of economic inequality and the literal worsening of the economic condition of working class whites, but is also redirected. The anger and resentment is redirected not toward Republican politicians who are doing the plutocratic work, but rather at Black people and women and Muslim immigrants and Mexican immigrants. So in that sense as well, the Supreme Court is a huge problem. But again, just to reiterate, I mostly want to quarrel with the premise that for Republicans to do something bad and authoritarian, Democrats need to do it first. I just think that's utterly untrue. Republicans will do all of these terrible things, pretend that violence didn't happen on January 6th, suppress the votes of Democratic leading constituencies, steal power of judges, pack courts. They'll do all of that regardless of what Democrats do. So Democrats have to decide when they're willing to fight back. So let me give you, I've talked for a long time. Let me give you just one more concrete example, which is partisan gerrymandering. So the reason why Republicans control the House right now, which they do very narrowly, is because of the extreme partisan gerrymandering in North Carolina.
Shelby County v. Holder.
Yeah, well, that played a role in liberating the gerrymandering. Yeah, and then the Supreme Court in Rucho said we're not gonna treat this as a justiciable issue. North Carolina is a very 50-50 state. So Democrats control the governorship. Democrats just won most of the state elected offices. Democrats lose the presidency by 2 or 3 points, but Republicans have a supermajority in the state legislature because of gerrymandering, and then they use that supermajority to gerrymander the congressional districts. So Republicans have their 14 congressional representatives in North Carolina. The state's evenly divided between Democrats and Republicans. You'd expect a 7-7 split. But instead, Republicans win, 10 out of 14 or 11 out of 14. I don't remember which it is. And that alone is enough to give them control of the United States House. So, in New York, Democrats control the state legislature. And the question is, should they gerrymander in response? And the Democrats in the New York legislature refused to do an extreme gerrymander. and Republicans won seats in New York that they could have lost if the Democrats had just gerrymandered the districts a little bit more to their advantage. But Democrats don't do that. And my point is, I think that's crazy. I mean, gerrymandering is a bad thing. It should be forbidden by court decision. It should be forbidden by federal statute. But if it's not forbidden and Republicans do it and it gives them an advantage in winning the House, it's crazy that Democrats don't do it. And that's the same thing I'm saying about court packing. But I acknowledge that autocrats pack courts, so we have to be sensitive to context and motivation. And I don't think it's autocratic for Democrats to do it for the reasons that I described.
Professor, if I may, if you indulge me with one counter argument. I agree with your argument that if something is not forbidden by the system, although it might be seen as morally wrong, if one side will use it and the other don't, the side that don't use it will lose. And this is game theory 101, I think. But in regard to court packing, I would say, for example, that court packing would be a tool to fight what Republicans do with gerrymandering. But I would disagree with the premise that the court is already packed, because even if we give back Merrick Garland, if Merrick Garland was in the Supreme Court, Trump would still have nominated at least 2 more people. So we would have not a 6-3, but a 5-4 majority. And you would argue, oh, but that is because of the system. We have the Electoral College, we have gerrymandering, and all of this is bad, and I agree with you. But isn't this features part of the game, of the rules of the game? And if they are parts of the rule of the game, how could we consider this a packing if this was done according to the rules?
There's nothing about expanding the Supreme Court that's contrary to the rules. It's clear that you can set the size of the Supreme Court by statute. It's clear in the 19th century, the size of the court was changed 6 times. So you're defining what Mitch McConnell did or the Electoral College, what it accomplished as part of the rules of the game, but you're defining expanding the size of the court as not part of the rules of the game. But I don't know why that is. It's right there. It's been done several times. It hasn't been done in the recent past, but Mitch McConnell also broke the norms about refusing to hold hearings on presidential appointments. 5 of the 6 justices were confirmed, 5 of the 6 Republican appointees were confirmed by such narrow majorities in the Senate that those senators did not represent a majority of the American people. Now, I'm not, as I said, I'm not an anarchist. I'm not going to change the Senate. It can't be done.
But you got me there. You have a great argument. Well, because court packing is part of the rule of the game in the U.S. because has been done over and over again. You are right in this point. I have to agree with you in this point. Although from a normative perspective, I would disagree.
Well, I mean, there are a lot of things we can argue about. So, normatively, should this be done? Politically, strategically, should it be done? I actually think normatively it should be done, partly for the reasons that I think sometimes you have to fight back with the same weapons that the other side has used. And, I don't buy the strategic. You say game theory 101, but I'd say game theory 101 is that if the other side makes a departure from agreed upon norms, the obvious response is to make them pay for it. Otherwise, they'll treat you as a sucker and they'll continue to defy the democratic norms. The Republicans have paid no price for the authoritarian stuff that they're doing. And yet, my guess is if Democrats tomorrow took control of the national government, they still wouldn't pack the court, because I think most Democrats don't understand the exigency of the moment. And if the stuff that Trump is doing right now isn't enough to wake them up from their, dreamlike state and realize how threatened the rule of law is, I mean, what's going on is just simply incredible. And any argument that, we need to be worried as Democrats not to provoke the Republicans by doing things that seem aggressive or norm breaking. I mean, they've embedded a private citizen into the national government, shutting down agencies, interfering with funding, firing officials, talking about defying court decisions, stopping prosecutions in order to have things hanging over the heads of mayors so that you can pressure them into supporting your political. I mean, we've never seen any of this before. We've taken a giant step in the authoritarian direction. And yet, I don't think Democrats would pack the court if they had the power, because I don't think most of them understand how dire the situation is. It's really quite incredible. And we should be talking about a general strike. That's what we should happen. We should be talking about all the lawyers in the Justice Department refusing to go to work tomorrow. We should talk about everybody in the country refusing to show up for work, because that's the only way to get people to notice what's going on and to take some responsive action. Republicans in Congress are utterly ineffective. They're just, cowards and sycophants. Anything that Trump wants, they're now giving him. So I don't know. The courts are doing a great job at the trial level, but they're mostly Democratic judges. I don't have any a doubt at the Fifth Circuit, the most Republican and extreme circuit court in the country. I think they'd uphold all this stuff that the administration's doing, and the Supreme Court somewhere in between. There's nothing protecting us, I don't think. Maybe the courts will play a role, but I haven't seen it. Not the court that decided that Trump is immune from any criminal prosecution. The only thing left is the people asserting themselves and insisting that they're not going to allow their democracy to die. But so far, we haven't seen much by way of popular mobilization. It doesn't look obvious that Americans are as willing to take things into their own hands as Koreans were. I think that's, pretty depressing.
Professor, I think we reached over an hour of our interview. I want to thank you so much for your time, your willingness to talk to us, and for such an enriching conversation. I hope we can talk again under other circumstances and talking about a less heavy subject, if I can hope so. So I want to thank you again and hope to talk to you soon.
Okay,
And
well, it was
see you
fun.
in 3 days in our class.
I'll see you in class, and those were good questions, and I enjoyed the conversation. So thanks for having me.
Thank you, Professor.
Okay.